Treaty has been ratified by 103 member states, and you can even say that they have become in the domain of customary law, so even states that have not ratified those treaties or that particular treaty could be held bound by it if it was coming before, for instance, the International Court of Justice. But let alone, it is true that any state that has space capabilities is a partner, is a member state of that Outer Space Treaty. So a way for states to implement that obligation is to have national space legislation. And this is something that is developing more and more, related to the ongoing privatization and commercialization of space activities, because it is a way for states to facilitate the implementation of that duty they have to authorize and supervise. It's not an obligation. States can implement authorization and supervision also in a less formal way than by means of a national space law. For instance, France has only enacted its law in 2008, but it was already a space power since many decades. It worked with implementing agreements and decrees and so on. But of course, this is the easier way to create, let's say, a kind of contractual link between the state, the government, and a private entity. The United Nations has recently done a great deal of work in this field. Also, there has been a working group that was created in 2009 and that culminated in 2013 on national legislation. It was headed by Professor Irmgard Marmbo of Austria, and that has resulted in a UN resolution that was adopted on the 11th of December and that contains recommendations, 8 recommendations to states that are thinking of enacting national space legislation. So that is guidance for the member states who are thinking about this and who need some input on what kind of elements they could include in such a law. I've put here a few links that will give you some information. If you're interested, you can find a very interesting table, a schematic overview, which compares various legislations and everything that they say about insurance, what they say about fees, what they say about liability, what they say about registration. So it's a table, a comparative table, that you find in that first PDF. And the second link is a database of national legislation that have been notified to the United Nations. It is, as I say, a database of laws that have been notified to the United Nations, so it is not the UN that goes out itself and puts these laws online. It depends on, waits for member states to notify them of these laws, which means that it's not always up to date. For instance, the French Act of 2008 was not there for a long time. I don't know if it's there now. I know that also the Japanese Basic Space Act of also 2008 is not yet there. And the reason is that perhaps the state has not finished the final translation into English, or that they are in the process of adopting another law or something like that. So it is not necessarily completely up to date, but it does give you a very interesting overview of what is there, what states have adopted national legislation. So who has to be authorized? That is another question. The Article 6 says activities by non-governmental entities. This does include private companies. It also includes universities. It even includes individual. If the time comes when small satellites become so small that we can even have our personal satellites, we would also have to be authorized. And I believe that that time will certainly come. The reason is, again, the states are responsible for the behavior of those non-governmental entities, whatever form they take. So that is the rationale behind this authorization procedure. What has to be authorized? Again, back to the text of Article 6, it says national activities in outer space, and they have to be authorized and supervised. States actually interpret this obligation in the way that they feel fit, that they see this corresponds with their national policy. For instance, a state can say, we will only apply this to activities that take place in our territory. Others can say, we also want to apply this to activities by our citizens in another country, personal jurisdiction, or the first one is territory or jurisdiction. So you can have different kinds of activities that can be authorized according to the interpretation of the state. Usually what you will see in national laws is that the activities of launching, operating of satellites and tracking activities and so on fall under the ambit of national space legislation and require authorization by the state. So merely doing research on a satellite or something like that, you will not need a license. But if you're going towards buying a launch contract, building your satellite and putting it into orbit and tracking it once it's up there, that is space activities, national activities in outer space, and you will require a license. Who has to authorize and supervise? And again, the text of Article 6 says the appropriate state. Here also there are different possibilities, and again it is the state, which is a sovereign entity, which will decide how it interprets this. It can look at the state whose company, where the nationality of a company is established, or the place where it is incorporated or has its major headquarters. The state that exercises jurisdiction and control, which is often, the state of registry. And you mentioned your example with countries A, B, C, and D, and my answer is to that. It may well be that you need several licenses. It may well be that you need a license from the state where your satellite is going to be launched, as well as a license from the company, from the country where your satellite is going to be operated and tracked and so on. So it is not necessarily so that with one license you're out of your drawbacks, as you call them. I want to stress, however, that all these regulations are not just drawbacks, because states can also help you in facilitating your business. If you fall under a national legislation that is positive towards innovation and that is open to facilitating space business, it can also include tax incentives and things like that. It can actually include and introduce a cap on your liability. Under the space treaties, there is an unlimited liability, as was explained before. So if you operate under national space legislation, it is not only drawbacks, it is also helping to develop your business, and also having a license will lend you credibility, and that will also be good for your clients and for your position in the market. So it's not all bad law. Usually the authorization authority is exercised by the ministry or agency that is in charge of space activities, and that depends. In some countries it's the Ministry of Transport, in others it's the Ministry of Science, so that really depends also on the situation in each state. Once you've gone through an authorization process, you're also not out of your troubles, because there is also the obligation of continuous supervision. The state is not only obliged to authorize your activity, it is also obliged to continuously supervise your activity. And the measure or extent of this supervision can depend on the kind of license that is given. Sometimes a license is given for each activity. For instance, this is the case in the UK. You have to apply for each new satellite that you're going to launch and operate and so on. In the Netherlands, on the contrary, you are given a generic license. So you're giving a license for the operation of geostationary orbit, satellites in geostationary orbit, for instance. So as long as you carry out that activity, even if you build and launch new satellites, you're operating under the same license. In that latter case, you will understand that the need for supervision is more strong than if you get a license for each launch, because then for each license you will go through a certain process. So that can also again depend on the situation in each country, what the extent of the supervision will be. So what is usually checked when you go through such an application process? And again, it's not an exhaustive list, it is just some examples. It's based also on the recommendations that I mentioned earlier, on the UN resolution. In any case, there will be a check of the safety of your project. So there will be a need to view your satellite composition, your technical documentation, your safety case, and what have you, compliance with certain standards and so on. They will also look at the financial health of your company, because if there is some kind of problem, liability or whatever, and the state would like you to reimburse it for damage for compensation that it may have to pay, it will like to know if your finance is in order. So they will do a check of your annual reports and your reserves and so on. In some countries, it is becoming more and more important also that they will require compliance with debris mitigation standards or kinds of environmental standards by requiring environmental impact studies, for instance. The effect on a state's national security interests or foreign policy interests can also play a role. If your satellite project goes against the policy of the state as a state in its international relations, it might not like that. It might go against its interests as a state, which are all things that can have an impact on your project. Of course, all this is in parallel to the whole filing process in the ITU, but even the obtaining of filing rights could be a condition for refusal of your license under the authorization and supervision procedure. So they do go hand in hand in a way. What will be specified in your license? All kinds of conditions. For instance, what happens if there is a collision of your satellite with another satellite? What are then the obligations? Do you have to have obliged insurance? Is there a limit on your liability? Does the state have a right of recourse? What registration parameters have to be provided? We just saw from Nicholas the whole obligations that a state has towards the United Nations. So states will have to make sure that they get this information from those private actors so that they can, again, fulfill their obligations to the UN. They will also specify the whole audit process. So the whole implementation of an authorization regime means that the state will explain to you, we are going to do an audit of your technical, and we're going to do an audit of your financial, and we're going to see if you have the proper insurance and so on. So that also will be specified in the process. What are the fees, if any? It may be the policy of a state not to charge a fee because they want to encourage innovation. What is the time limit for giving you a license? Sometimes there is a 6 months period, or sometimes it's shorter or longer. What are the conditions for transfer of ownership? Can you transfer a license or not? Do you need permission? Can the license be revoked? Can there be penalties? And so on. Again, this all depends on the policies of each state. There is no one system that applies to each government. Usually you will have to go through the websites of your government, of your relevant ministry in charge of space to see how you have to apply. Usually it is recommended to start talking with that agency or ministry from the start and not wait until your satellite is built and you're ready to launch. It's usually better to go and see them from the start of your project so that you know what will be required. Some states have very good guidance on their websites. The UK is a very good example. They have extensive manuals, drafts of the forms and so on. And in other states there is less experience in this. You will have to start assembling the documents that you will need, and I put here a notice that you will have to be careful of export control issues, because sometimes you will come across the request, for instance, to see the contract of your satellite, but if your satellite happens to be built in the United States, you may not be able to give them that because it is restricted by ITAR regulations, for instance. So do all that on time, submit your application, go through the process, and then hopefully get your license. Just 2 more slides, a few words on the case of the Netherlands, because we have had a process that has been quite interesting in relation to the small satellites. Up till now, the Netherlands Space Act, which was adopted, came into force in 2008, did not really cover small satellites which are not maneuverable, which is the case for many of the CubeSats and the nanosats. The problem was that national activities in outer space, that sentence from Article 6, was translated into the national law as meaning launch, guidance and operation of objects in outer space. They were neither launched from the Netherlands, because we do not have any launch pads, but they were also not guided and operated from the Netherlands because they were unmaneuverable. So until now, this means that small satellites in the Netherlands did not need a license. So discussing with the authorities, it was concluded that that was not a desirable development and that there should be a solution to